Let's dive deep with a few legal gems that you can use in your business today. Yes, today. Stay tuned.
Welcome to the HR Signature Links show. HR Signature Links was born out of a desire to link human resources professionals and businesses. The HR Signature Links show is where you can hear from experts in the field of human resources as well as those that provide services to employees. We will explore the latest trends and insights and out-of-the-box concepts being explored in the world of human resources. So sit back, relax, and join us as we explore on HR Signature Links show.
Welcome to the HR Signature Links show. My name is Chessie, and I am so excited to be here with you today. We have some exciting information to share with you. But before we get started, let's just review what HR Signature Links is all about. We are certainly here to connect businesses with HR professionals and resources that you can use to operate your business daily. So for today's show, we have with us Carly. She is an attorney in the Florida area. She deals with employment law and helps businesses and employees navigate through certain situations. So today she's going to share with us some gems and talk about things you can use in your everyday business. So without further ado, I'd like to welcome Carly to the show.
Hi, Chessie. Thank you so much for having me.
Yes, thank you for being with us today. I am really excited about all that you're going to share. So we're going to dive right in. But before we get started, Carly, can you tell a little bit about yourself and what you do?
Sure, absolutely. I am a Florida employment attorney. I represent mostly businesses on employment matters. I spent the majority of my career litigating, so I have a very good idea of what happens on the back end when, unfortunately, businesses don't comply with the employment laws and get sued by their employees. So I spend the majority of my practice now engaging in preventative steps and preventative measures for my clients to make sure that they are complying with the employment laws through free legal workshops and trainings and investigations and things of that nature.
Awesome. So Carly, though you're in Florida, the information that you're going to share with us today can, if not all of it, most of it can be utilized throughout the country, correct?
Absolutely. So a lot of the information that I'm going to be sharing today relates to the federal employment laws, which affects everybody in all states. Some states have certain situations that might come up that don't apply to Florida. So it's always important, like I always say, there's a disclaimer, make sure that you consult with someone in your state, an HR consultant or an employment attorney in your state who would know those specific state nuances. But yes, you're correct. This will apply to the federal laws.
Awesome. So here we go. We're getting ready to dive in. So the first area is hiring and firing. Let's talk about that a little bit. What information would you have to share with businesses, new businesses, or existing about hiring, firing, and what they need to know legally?
Yes. So hiring and firing, it's really important because it's, in my opinion, the number one way that the company is going to get sued by their employees. A lot of people think if you're in an at-will state, Florida is an at-will state, many other states are at-will, so they can do whatever they want, right? But there are a lot of local, state, and federal laws that apply to your company when you are hiring employees or independent contractors. And so it's really important to make sure that you are complying with those laws, even if you aren't in an at-will employment state. When it comes to hiring, I think something that a lot of people and businesses don't realize is that the employment laws apply to people who do not yet work for your company. So it's not just your employees, but it's the people who are applying for a job, going through the interview process. So all of the employment laws that you may already know about or that we might discuss today will apply to all those people. And this comes into play in your job postings, right? What does your job posting look like? What is the language that you're using in there? Because a lot of times the language that you're using might be illegal. The applications that you are using, and I'll give you an example. So asking the date of birth on your application, that's basic information, right? A lot of people ask for it, but it can be seen as discrimination based upon age. If you're asking for a date of birth, now you know the person's age, you don't hire the 70 or 80-year-old person. You could be caught in a failure to hire based upon discrimination based upon age type of claim. So there's a lot of moving parts in the hiring stage, a lot of laws that apply in the hiring stage. So it's really important that businesses are aware of that as well.
Awesome, awesome. One question I always get is about onboarding, and certainly when you're telling people to bring their documents, their I-9 documents on the first day. Carly, please share some information about us. Why should we not say that, or what can we say?
So the issue with the I-9 documents is that national origin is a protected class. So you're going to want to make sure that you're aware of the protected classes. There are a lot of them. Everybody essentially these days falls within some sort of protected class, depending upon what the makeup of your company and the department that they're working in. There was just I'm going off topic a little bit, but stay with me. There was just a recent lawsuit that settled for a very large amount of money. I don't know what the exact figure is, but it was in the press that a white male was able to recover because he said that he was excluded. They were looking for females for the job. And so it's really important to keep that in mind. And so the protected classes are things like age, disability, gender, national origin. And so similar to asking the date of birth at the time of hire, when you are privy to someone's national origin or the country in which they're born in, there could be a claim that you're using this information and then not hiring that person. So there's, as you can see, there's a lot of moving parts. You just really need to be aware. My main thing that I want businesses to know is be aware that those laws are out there, and know that just because you're in an at-will state does not mean that you're in the clear with regard to all these steps that you're taking.
Absolutely. Good clarification. That's good stuff. But in that same vein, can we talk about employees versus contractor and their status and how businesses classify these two categories or groups? Can you talk to us a little bit about that?
Absolutely. So this is a huge topic. I can go on for a very long time on this topic. So a lot of companies want to hire independent contractors because it's easier or cheaper or whatever reason, right? And so you cannot contract away the designation of whether you have an independent contractor or an employee. If you do that, the Department of Labor is going to come to your business and ask why you're doing that, potentially tell you that you're doing it incorrectly, and require you to pay fines, penalties, and back wages if applicable. So it's really important that you get this designation correct. It relates to the type of job that's being done and the amount of control. Typically, states have different tests. California is one of the strictest tests, but in general, of course, it relates to the amount of control the business has over the person. So if you're a company and you have a lot of control over the person, you're telling them when to be at work, they're setting their hours, you are giving them a computer, they are using your email address, you are giving them the tools that they need to have. This person is probably going to be designated as an employee, especially if they don't have their own company, their own insurance, things like that. So there's a test. These people need to be classified properly for the reasons I told you. And the problem is that if the Department of Labor comes in and finds that you are misclassifying one person, they are probably going to find that you are misclassifying the rest of your people. Yeah. And depending upon the size of the business, there could be exponential penalties and fines and back pay, because if these people that you have working for you, let's say they're working overtime, but you're not paying them overtime or whatever it might be, that could be a lot of money that the company can owe going back several years.
Yeah. And that's scary, Carly, because sometimes small businesses, they just don't know it. They're trying to do the best they can. So to say, with all of that said, I guess they should start with a job description, right? Making sure that it's clear, concise, and then what should they do from there?
So the job description is absolutely going to come into play. And I feel like the job description is something that's overlooked a lot. Like job description, they know what they're supposed to do, right? They're here to do their job. They know. But the job description is exactly like you said, it's going to lay out the specific details of their job duties to prove or disprove whether or not they're classified properly, right? So if they're supervising employees, what kind of tasks they're doing, the type of control, you're going to look to the they are going to look to the job description for that. They could also potentially look to see if you have an independent contractor agreement. Now, of course, again, this is not dispositive and you can't contract away. You just can't call it an independent contractor because you want it to be one. But more oftentimes than not, if you have an agreement that lays out like the duties, the responsibilities, this person's responsible for their own insurance, they have their own company, payment obligations, things like that, it might help to tip the scale in favor of an independent contractor if that's the situation that you have set up.
Awesome. And just to start this process, they could probably get with an attorney, right? Or there's some criteria. Where can they find criteria to just start this process?
So the criteria is on the Department of Labor website. It's laid out very nicely, but it uses a lot of legal terms. And so, of course, I would recommend consulting with an employment lawyer. It's not as difficult and daunting as it might seem. Find one in your state that you would be happy to work with. And a lot of employment lawyers, they're paid hourly, they work on a retainer, and you can contact them. For instance, I have a package that I offer that's an HR audit. And I will go through all of your business practices and make sure that number one, what you are doing is legal and that you're complying. And number two, that you're set up in the best position possible so that if a lawsuit is filed against you, that you're in the best possible position to defend it with documentation, handbooks, policies, things of that nature.
That's awesome. A step-by-step guide, and we'll definitely make that available for everyone as well. So we talked about hiring and firing. We've talked about employees and contractors. Now let's move into paying employees in the right way. What do they need to look out here?
Yep. And this is a kind of, goes right into the Department of Labor, the classifications and the Department of Labor audits. I recently represented a company it's a new company. They're hiring a lot of employees fast. And unfortunately, they relied on their payroll processing company to make sure that they were paying their employees properly. And this is not the type of relationship that was set up. So for instance, are you paying your employees hourly or salary? And again, this is depending upon a legal test. You cannot just pay someone a salary because if they don't fit within the exemptions under the FLSA, because what happens is if they're really supposed to be paid hourly based upon the job that they're performing and they work overtime, you could be responsible for paying the overtime rate times 365 days a year, however many days they're working, times 2 to 3 years or whatever it might have been. So again, it's just a great deal of exposure for businesses who don't know how to properly set these things up. So that's one, properly paying a salary or hourly, making sure that you're paying the correct overtime rate. So, do you include bonuses? Do you include tips? Do you include commissions? Are you paying for travel time? If there's travel time to different work sites, and how are your employees keeping track of their time? That's another really big one. So the Department of Labor, and you can find this on their website, requires businesses to keep certain documentation for a certain amount of time. I think it's 2 years and 3 years. Okay. So you have to keep payroll records. You have to keep the time punches, the clock in and clock out. Like I said, I recently represented a client who was going through a Department of Labor investigation, and there were no time records because they were paid a salary, but they weren't supposed to be paid a salary. They were supposed to be paid hourly. So you're stuck in a position where you're not only not paying these people correctly, but the Department of Labor is upset because you don't have the documents that you're supposed to have. And you don't want the Department of Labor coming into your business digging around, because they're digging, they're going to find something, they're going to find other things that you're doing wrong. And it's a little bit of a snowball effect. So
yes, definitely. You don't want that. Question. So For differentials, I think you also need to look at your county and state, right? Because you might have to pay differentials for overtime or on call, things of that nature. Is that correct too?
Right, exactly. So, and that's kind of getting into specifics. So, if you are a company who the employees are paid tips or bonuses or commissions, or exactly like you said, the differentials, different requirements of calculating overtime, it gets really tricky and complicated and you're dealing with numbers. So yeah, absolutely. You do want to take a closer look at that. Also, something that has come up a lot that I want to share with you is a lot of companies have a no overtime policy, right?
Ah,
We don't want anyone working overtime. Because we're trying to establish a budget, right? That's understandable. You're only allowed to work 40 hours a week because we want to get a handle on this. While we appreciate you doing your job, we don't want to find that you're working 60 hours at the end of the week. So that's fine having a no overtime policy. But the problem arises when, let's say somebody works more. Let's say they go over 42 hours, 43 hours, 44 hours, and the company says, absolutely, we have a policy against that. We're not paying you. You have to pay the employee working overtime. And it's tricky because now do you write them up for violating the policy, or how do you handle that? And I say it's tricky because overtime issues and complaining about overtime and raising overtime concerns is a protected activity. And once the employee engages in a protected activity, which is something that's protected under the law, right? Their right to be paid overtime is protected under the law. You could potentially open yourself up for a retaliation claim if you now go fire the person because they're violating your policy. So, it gets a little tricky in there. And that's why I always say, and I always defer to, just reach out to your employment attorney, run it by them, give them a quick call and say, this is what's going on? Is this something that I can do? Do I need to do something differently? Can I fire this person? Do I need to wait a month before I fire this person? Etc.
that's so good. That's so good, Carly, because again, I don't think any business is intentionally trying to break the law. It's just they don't know what they don't know. So
Exactly.
this is amazing information. Good stuff.
Exactly.
What about some essentials, Carly? Just some essentials that you think, I call it basic 101. You might be like, no, Chessie, it's not basic, but what are some things that you think businesses you need to know this, you need to make sure this is documented, this is in place? What would you say to that?
Oh, there's a lot of things. Let me think. So the biggest one probably is, well, I can't even pick one. You're making this very difficult for me. Other than what we've gone over. I mean, pay is really important, right? Because it has to do with someone's pay, what they're paying, what you're paying them. And it's very easy and free for them to go and complain to the Department of Labor. So that's a big one. The next big one that I would say would be firing an employee, because it opens the business up to so much liability at the time that you fire somebody. They have just lost their ability to earn an income to support their family. They have nothing to lose, so they can go file an EEOC charge, again, for free. So if I were to have to pick one, I would say when businesses are terminating employees, be very careful, because there's a lot of wrongful termination type claims that can be asserted. You want to make sure that you have your documentation in place to defend yourself. Because again, even though we're at will, there are a lot of wrongful termination type matters. And then there's also a bunch of other documentation that